Are you telling me some lower level district court judge was able to overturn the president's entire agenda because he had some, axe to grind? No, obviously that's not what happened. But do you want to know what did happen? How about we talk about it? I'm Brian. I make videos about civics and law. Please share this, comment, get this out there so people see it. Today we're going to be talking about preliminary injunctions, which is what was issued in the Doctors for America case. Then I'm going to make another video where we actually apply what I teach you today to that case. But first you need to understand what a preliminary injunction is. So pay attention. I've got some really important stuff to teach you. All right, you ready? Let's go. Let's start by kind of sketching out what happened, okay? So, step one, President Trump issues Executive Order 14168. This is an order related to gender identity. It requires any agencies to remove any sort of policies or anything else that reference any sort of gender ideology or anything like that, whatever that may mean. Then we have step two. On January 29th, we have an Office of Personnel Management memo with initial guidance on how to interpret the executive order. Followed by step three, sometime around January 31st, the FDA and CDC remove certain datasets and web pages. No advance warning is given, but a statement is issued afterwards saying that they had been removed. And finally, on February 4th, 2025, Doctors for America files civil action 25-322 in the District Court for the District of Columbia. And that's the case we're going to be talking about today, but not just the fact that they filed the case. They also filed a request for a preliminary injunction. And a preliminary injunction is something special, which we're going to learn about right now. All right, real quick, we're going to talk a little bit of civil procedure. When you file a case like this in civil court, the first thing you file is called a complaint. That's what sort of opens the case. Complaint. Of course, the person who filed this is called the plaintiff. Now, the next step is that the defendant needs to file an answer. In this case, it's the US government. And then a bunch more things are going to need to get filed, and this is going to go on for months or even years. But what happens if the complaint that was filed is time sensitive? If whatever problem is being caused that's mentioned in the complaint is getting worse every day? Well, in that case, the plaintiff can request a preliminary injunction. The plaintiff would ask the court to stop the defendant from doing whatever they're doing in the meantime until the case can be resolved. In this case, the web pages and data sets that were taken down were used by Doctors for America to do their medical work. And without those websites and data sets, they were hurting their patients. So they are asking the court to force the government to put these back up in the meantime while they settle this case so they can continue to do their medical work. But the court doesn't just haphazardly agree or disagree. There is a whole process to figuring out whether or not this is something they want to do. Let's say I'm digging on my land, but I'm really doing some damage to my neighbor's land. And my neighbor sues me to stop me. I know I've actually only got a couple of months left of the work that I'm doing, so I just go ahead and keep doing it while they sue me. By the time the lawsuit's over, I'll be done anyway. Well, the lawsuit wasn't much good then, was it? In that case, a preliminary injunction stopping me from digging while the case was going on might seem like the fair thing to do. On the flip side, let's say somebody's digging on their own land, really nowhere near mine, and I just don't like them. So I go ahead and sue them to stop them, but I really don't have a legal leg to stand on. In the end, I'm gonna lose this case, and they're gonna be able to go ahead and keep doing what they're doing. But I go ahead and file for a preliminary injunction anyway, because over the next 2 years while we're fighting it out in court, they can't get done what they want to get done, and it's going to basically stop them from being able to do it. That isn't really very equitable either. The verdict of a civil lawsuit is supposed to determine the correct outcome, but the fact that a civil suit can take 2 years should not itself be what determines who wins or loses. And so things like a preliminary injunction can stop damage from happening while a case progresses. But carefully restricting preliminary injunctions make sure that damage doesn't occur because of them. So let's talk about the rules we use to determine whether or not they are being equitably applied. And for those of you who have watched my video on equity, try to forget all of the history right now. That's not going to be so important. What is important is the theory behind it, and I will point out to you when equity kind of plays into this. But as I said in the equity video, most lawyers don't even notice when they're filing an equity versus filing a common law. It looks on its face almost the same. One more thing to watch for here is that these tests have been written over years and years in an attempt to create something as close to an objective test as possible. Obviously, the idea of equity, fairness, is not objective. It's clearly subjective. So we've created these 4 tests to try to make the decision of whether or not to apply equity as objective as possible. So keep that in mind as you're looking at how these tests are formed and how they're applied. Okay, 4-part test. So this is our 4-part test for a preliminary injunction. Let's talk through it, shall we? Now remember, the plaintiff is the one who filed this case, so they're the one who are going to be requesting the preliminary injunction. The first question the court has to address is whether there is a substantial likelihood of success on the merits. Just looking at it in the abstract, is there a substantial likelihood that they're going to win? Not 50-50, not 60-40, substantial likelihood. Because if this whole thing is just a tactic, then the court doesn't want anything to do with it. This is an equity thing. We're supposed to be fair. So that's the first thing. Are they pretty likely to win? And that's a tough bar. But keep in mind, this is a likelihood of success on the merits at the district court level. There's a possibility that they'll win in the district court and then lose with the Supreme Court, and the judge may know that. But that's not what this is asking. The judge is supposed to look at the law as it stands right now with no changes from the Supreme Court and make a objective, clean decision about whether it's probably going to go one way or the other. If it looks like it's probably going to go one way, then we've met this factor. This is already a really big hurdle to get over. This cuts most cases out. These may not always seem like objective standards, but by pushing them so far, they do become significantly less subjective. Let me give you an example. In discussing likelihood of success, we could say the likelihood is minimal, modest, substantial, or considerable. Now, I'm not entirely sure whether substantial or considerable is higher, and that's a question of subjectivity. But I do know that they're significantly higher than moderate or minimal. So while there may be a little bit of subjectivity between considerable and substantial all the way up here, by pushing them all the way up into the stratosphere, all the way up to this end, we've removed a lot of the subjectivity. They still have to reach a very high bar. Substantially likely to succeed is a really, really high burden. So once we've met that, we've already narrowed down a lot of the field. Now the next question is, will there be irreparable injury if this is not granted? The plaintiffs will list what injuries they have in the complaint. So the court will look at those injuries and see if they are potentially irreparable. If they're nothing but money, that is never irreparable. Money is always fungible and can always be repaired with more money. But think back to our equity discussion. If this is something like a house being knocked down, we know that a house is considered something kind of special. A house may not be able to be replaced. So a court might stop somebody from demolishing a house in the meantime because that damage would be irreparable. But we have another very high hurdle on our hands: substantial likelihood and irreparable injury. Both high hurdles. And just as we tried to make the first requirement as objective as possible by pushing it all the way to one end, by making the injury irreparable in the second requirement, we also pushed that one pretty far to make sure it could also be as objective as possible. And by case law, we removed things like money from the definition of irreparable to ensure that there's even less subjectivity. Now we've gotten to everyone's favorite, the balancing of the equities. With the balancing of the equities, we have thrown objectivity out the window. There's no way to do this one objectively. But this is equity. It doesn't have to be objective. And we've done what we could to make the first two requirements objective. Now, the balancing of the equities sometimes is a little bit different in different courts, but the general idea is that you're going to look at the damage that's going to be done to the plaintiff and the damage that's going to be done to the defendant and see which one is worse. The idea is that even though you've made it this far into the inquiry, you don't end up doing more harm than good by allowing this preliminary injunction. Sometimes a court won't bother looking at the plaintiff's damage, considering it's already probably talked about it quite a bit, and instead will just focus on the damage to the defendant. And they'll ask here whether a preliminary injunction would substantially injure a defendant in this case, or sometimes any other parties involved. But this is good, solid equity stuff. We went through two standards that were as objective as we could come up with under the circumstances, and now we're going to balance good old-fashioned equities and see what comes out on top. And speaking of equity, we now finally get to our fourth option, the public interest. In other words, what impact would granting this preliminary injunction have on the public interest? And there are things we have to consider here, like, for example, I talked earlier about cases or preliminary injunctions acting as a sword. If people come to believe that the court system can be manipulated to their own uses, and rather than waiting for a verdict, they can use the civil procedure system to get what they want, that's not a good thing. So overuse of preliminary injunctions, for example, would be bad for the public interest in that sense. So that's the sort of thing they might consider. In this case, we were talking about public health information. So obviously the public interest could be impacted by the availability of public health information. But there are all sorts of questions that could go into the public interest. But this is where they get to consider the public at large and not just the parties here. Because once again, this is equity, fairness, not just fairness to the parties, but fairness to us. Equity is about something bigger than just the law. Okay, so that's a brief rundown on preliminary injunctions. And if you go look at that Doctors for America case, you will see them go through these four tests. I have a feeling we're going to see a lot of preliminary injunctions coming up. So knowing this framework is going to be really important over the next couple of months. Once again, I got to thank everybody who's been supporting me through Venmo and Amazon wishlist and everything. Mark, Barb, Kimberly Lopez, Casby, Desiree, thank you guys very much. And get this stuff out there, guys, so people will keep seeing it. And if you haven't watched my video on equity, go check it out. All right, thanks a lot, guys.